Hello, how are you? I hope you all are fine. Let's today discuss the topic of a Hindu son paying back the debt taken by his father, grandfather, or great grandfather. So, is a Hindu son liable to pay back the debt which was contracted by his father, grandfather, or great grandfather? Under old Hindu law, during Smriti era, during the ancient Hindu law, it was the rule or it was the law that if a father, grandfather, or the great grandfather took some debt, then the son or the grandson or the great grandson was legally, morally, and religiously liable to pay that debt. It was his pious obligation to pay back that debt, because in case he doesn't do so, then the soul of the father, grandfather, or the great grandfather who died before paying that debt, the soul of his ancestor will not rest in peace. That was the practice in earlier Hindu law. His soul will not rest in peace. So, in order to make his soul rest in peace, in order the deceased grandfather's soul or the deceased grandfather would go to heaven, not to hell, to heaven. It was the pious duty of the son or the grandson to pay back all the debt taken by his father, deceased father or grandfather who died before paying the debt. Even the son's own debt who he has taken, that debt he need not to pay until and unless he had paid his grandfather's or father's debt before. It was his duty to pay first that debt taken by his father or grandfather before paying his own debt. That was the religious, moral, or you can say the legal duty in earlier Hindu law, in the ancient Hindu law during the Smriti era. So then came this British era, in which the British ruled over India over, I think, more than 200 years. So during British period, there was Privy Council, the Supreme, as we have Supreme Court nowadays in India, independent India. In those days when the British came and ruled over India, the highest court was a Privy Council. Privy Council in many of the decisions said that it was the legal duty of the son to pay back the debt taken by the father, grandfather, or great grandfather, and it was his legal duty. He has to pay that debt. So then after independence came the Hindu Succession Act 1956. So what change it made? Actually, Hindu Succession Act 1956 in section 6 said that it was the duty of the son to pay that debt of the father or grandfather, and there was no change howsoever in the earlier or the ancient Hindu law. The same law was incorporated in the Hindu Succession Act, and the son was liable to pay for the debt taken by the father. But here one thing I have not told you earlier, and that is that the father or the grandfather who died before paying his own debts, that debts which he had taken, the deceased father or grandfather, which debts which he had taken, those debts should have been vyavharik debt, not avyavharik debt. So two type of debts were there in earlier Hindu law: vyavharik debt and avyavharik debt. What is avyavharik debt? It means debt taken for consuming liquor, debt taken for doing all the illegal activities, debt taken for gambling, debt taken for prostitution, debt taken for all the immoral activities. So if the father, grandfather, great grandfather took that debt for all these illegal and immoral activities, then his son or grandson whatsoever is not liable to pay that debt, because that is avyavharik debt. That debt is not vyavharik. So what is vyavharik debt? Vyavharik debt means the father, grandfather, or the great grandfather had took the debt for family necessity, for the marriage of the daughter of the female member of that family, joint family, or for the benefit of estate, or to sell the estate to get a big estate or good estate. You see, same thing as benefit of estate. It means the karta or any grandfather, great grandfather, or any male member of the family had took the debt for vyavaharik things. That means it is for some legal necessity, not for immoral things, not for illegal things, not for gambling, not for any other entertainment type of thing, not for consuming liquor. It is for family necessity. So then sons are also liable to pay back the debt if the father or grandfather, after taking the debt that is for necessity, for family purposes, died before paying back. He died before paying back to the creditors. So now it was the legal, moral and religious duty of the sons or grandsons, whoever were left in the family, the kaparsoners, male kaparsoners, basically they were under legal, moral or religious duty to pay back the debt, because that was vyavaharik debt. That debt was taken for necessity, family necessity. It was legal, not illegal, not for immoral purposes. So that was known as the pious obligation. And if they didn't pay back in British courts or in during the Privy Council era or the British era, the creditors would go to the courts, and he can file the case, civil suit against the sons and grandsons on the basis of this pious obligation. But what happened in the Amendment Act of 2005? I am talking about the Hindu Succession Amendment Act 2005. Hindu Succession Act was passed in 1956. So Hindu Succession Act 1956 was amended in 2005. So in the amendment of 2005, it was said under section 6 clause 4 of the Hindu Succession Act. It says that now the creditors will not go to the court to enforce this pious obligation against the sons or grandsons. They were not able to go to the court to file a suit against the sons or grandsons for discharge of the pious obligation. So this pious obligation concept has been totally nullified. It has been cancelled, or you can say it has been done away with by this Amendment Act. Now sons, grandsons or great grandsons will not be harassed, or they will not be sued in the court by the creditors of their ancestors who had died, just for the sole purpose or sole object that the father or the grandfather who died before giving back the debt, he died, and now it is the pious obligation of the son or grandson to pay back the debt. Just pay back the debt. So just for the purpose of pious obligation, the sons or grandsons will not be held to be liable in the courts of law, and the creditor will not go to the court, and the court will not accept his petition. So this was the change made under 2005 Amendment Act of 1956, Hindu Succession Act Amendment Act 1956. So 2005 made a great amendment. Then in this amendment, even the daughters were given the equal rights as compared to the male members, as compared to their brothers. They were given equal rights in the joint family property. Now they were made the equal kaparsoners. Earlier only sons or male members were kaparsoners, but after 2005 Amendment Act of Hindu Succession Act 1956, even the daughters of the female members of that joint family were given equal rights as the male members, and they can file a suit for partition. They can ask for partition. Even the any male member can ask for partition. Any male co-partner can ask for partition, and even the female member can ask for partition. Now that's a different chapter, that's a different topic. Here we're discussing about the pious obligation of a son. So if the pious obligation of the son has been done away with, then there was no need of the daughter also to pay back the debt. Even earlier also, before 2005 amendment, the daughters were not liable to pay back the debt. Earlier in ancient India or ancient Hindu law, only the sons were liable to pay back the debt. under the topic of pious obligation, because at that point of time only sons were liable. Why? Because daughters were considered the property of the joint family. They were considered the property as male members. So that was a patriarchal mindset at that point of time. Daughters were not given equal rights in the real estate or the joint family property. But after 2005 amendment, daughters were given equal rights as the sons in the joint family property. They are equal co-partners. They can ask for partition also. They are not having now limited rights over the property. They are made the full owner of the property. Whatever property will go to them according to class 1 heir or class 2 heirs, according to the intestate succession. You see, so Hindu Succession Act 1956 tells about the intestate succession or testate succession. You see, so now the property will go according to the succession table given in the Hindu Succession Act 1956, not according to this the prior law of survivorship. Survivorship has been done away with by the Hindu Succession Act. Now only through succession, intestate succession or testate succession, the property will devolve. Whether the joint property, for example, ancestor dies without making any will or doing anything about that property will or joint family property will devolve to the the members of the family according to the table given in the Hindu Succession Act, that is class 1 heirs or class 2 heirs. So that was a little bit different topic. So main topic here was, what about the pious obligation of the Hindu son to pay back the debt taken by the father, grandfather or great grandfather. So now after the amendment of 2005, no pious obligation as such exists, and the creditor can't go to the court against the son or grandson or even against the daughter just for the sole purpose of enforcing the pious obligation of son to pay back the debt. Yeah, if during taking the debt these days, for example in the present times, if the father took any debt and in the written deed son or daughter is made as a legal representative or the nominee, or you can say legal representative, or there is a line in the deed in which the son is made liable in case the father dies, then son is also liable to pay the son is liable to pay the debt, then it will be enforceable in the court of law. Then that written deed will be enforceable in the court of law. If anything is not written in that deed, then the son is not liable. If the son is made legal representative, if he is a legal heir to the father, and the court will read all the instructions or all the written document or whatever document they had made, the creditor and the debtor. So main written contract, whatever they had made, the court will read that contract, and according to the contract the court will decide the case. If nothing as such is written in that contract between the debtor or the father or grandfather and the creditor, the son, just for the sole purpose of pious obligation, enforcing pious obligation, he will not be liable in the court of law. Otherwise the court will read out the whole contract between the debtor and the creditor, and according to the contract the court will decide the case. Thank you very much. I hope you like this lecture.